So now we need to talk about some different types of contracts, and y'all, we are going to be talking about obviously quite a few that pertain to real estate, obviously. And I will tell you, y'all, this is a pretty big module or chapter here. And when I say pretty big, for test purposes. My guess is this is probably one of the, if not the chapter, that will have the most questions on the exam. Because obviously that's what we're going to be doing a lot of when we're practicing real estate. We're going to be writing up contracts, at least for most states. I know there are some states that it's not legal for real estate agents to write up contracts, and we'll talk about that a little bit. But most states, real estate agents will do this. But my point is, y'all spend some time here. Make sure you understand some of these terms, what they mean, how they work, because you're going to be asking people to sign legal documents, these contracts that are binding. And it's critically important that your clients understand what they're agreeing to. And the only way they're going to understand it is if you understand it. So, this is a significant chapter right here, not only for test purposes, and certainly for test purposes, but this is important just to practice real estate. You've got to understand contracts, okay? All right. So what are we going to be looking at here? Obviously we're going to have to obtain some general knowledge concerning contract law. We're going to look at listing agreements, buyer agreements, offers, purchases, counter offers. Anyway, I'm not going to read all that to you, but you can see, there's quite a few things there. And again, this is going to be a significant chapter for both test purposes. A lot of questions coming out of this chapter. And you better know what you're doing when you get out there and start practicing real estate when it comes to these contracts. All right. So let's just start out with some terms. First of all, occasionally you hear the term expressed. Expressed agreements or contracts. And obviously you can express something in one of two ways, either orally or in writing. Now, I will tell you, in most states, if not all, when it comes to an agency agreement or contract, if you're going to enter into an agency relationship, we've talked a little bit about that in, I think it was the second chapter. Remember talking about brokerage relationships? And one of those options would be to establish an agency relationship, which is a fiduciary or legal relationship. Typically those have to be created or expressed in writing. Okay. But then you also see contracts of sale must also be in writing. Now, what I want you to kind of pay attention here a little bit is, agency contracts have to be in writing, but what requires it to be in writing? Typically, state law. That's a state statute that requires it. That's not necessarily a national or federal law. So state by state, and again, we get into the state-specific portion of whichever state you're in. We'll address this a little bit more. But I will tell you, most states require agency relationships to be created in writing, and that's due to the state law. But then you notice contracts of sale obviously also have to be in writing. But something different requires that to be in writing. And you notice it says that's required by the statute of frauds, which we're going to be talking a good bit more about as we go through this chapter. But for now, the statute of frauds, now that's a national law. So that's the law. No, I don't care what state you're operating out of. Contracts of sale have to be in writing. And basically what this statute is saying, the statute of frauds, it's just saying that any type of contract that is subject to the statute of frauds must be in writing. And there are other types of contracts that would be subject to the statute of frauds, but obviously contracts of sale would be one of them. So they have to be in writing. And we'll look at what these other contracts are that fall under the statute a little bit later. Okay. Implied contracts. That means we've got an agreement, but it's been expressed orally. There's nothing in writing. It's just implied. Well, how do you create an implied contract? It's just established by the acts of the parties. For example, say I have somebody, in fact, this actually happens. I'll use it as a good example. Several years ago, one of my neighbor's children came up to me and asked me if he could cut my grass, which, and if anybody knows me, I'm in favor of that. Anybody else who would like to cut my grass, I like that idea. I don't particularly like cutting grass. So for him to ask to cut my grass, I was all in on that. And we came up with an agreed upon price. And so he cut my grass. And when he got finished, I gave him his money, which I will tell you was $20. So this was a few years ago. But I gave him the money. And it seemed like a couple weeks later, I remember I came home from work one day and noticed my grass had been cut again. Now, I didn't know for sure who cut my grass, but I know who didn't cut it. And so I only assumed it was the neighbor's child had just come over and cut my grass again. And sure enough, I hadn't been in the house long before I heard him knocking at the door. "Hey, Mr. Griffin, I cut your grass again today." I see that, and thank you. And I gave him another $20. And then, my grass just kept getting cut. And now, look, when we initially had this conversation, it was just, in the way I thought, it was just going to be like a one-time thing there. I figured he just was trying to do something to raise some money for that one time. But he'd cut my grass, and I'd pay him, and we just did that for a little while. But what if I decided I'm not going to pay him one day? In fact, he comes up to get the money, and I said, "You know what? I did agree to pay you this money to cut my grass the first time we talked, but I never agreed to all this cutting after. I never agreed to that. And I'm not paying you for this. So unless you just like cutting grass for free, I suggest you quit cutting this grass, because I ain't paying you anymore, and I ain't paying you today either." Now, if I did that, and if he decided to sue me, in a courtroom, based on that scenario, what chances would he have of actually winning in a courtroom without a written agreement? And, typically in a live class, I get all kinds of response answers, but at the end of the day, I think most tend to say, well, it would not be enforceable because if you don't have anything in writing, so it wouldn't be enforceable. Well, that's not true. He could easily show that we had an implied contract. Now, yes, that's basically oral. There's no written agreement. So are you saying that there are some implied contracts that are enforceable in court? Yes, I am. Absolutely, I'm saying that. If you can show, all he had to show is that he would cut the grass, I paid him. He cut it again, I paid him. He cut it again, I paid him. Those actions by both of us created the contract. There would be no reason for this child or kid, young man today, there's no reason for him to think if he were to cut it today, then he would get paid today, because that's what we've done in the past. It's implied, right? And it would be enforceable, and the court would require me to pay for the cutting of grass. You ought to have to pay for it. So anyway, so what types of contracts or what types of implied contracts can be enforceable and which ones cannot? I mean, how come some contracts can be implied, oral, and some contracts have to be in writing? And how do you know which would be which? Which type has to be in writing, which one doesn't have to be? Well, it's pretty simple. What does your state law say? A lot of states have passed laws that clearly state that certain types of contracts must be in writing if you would have it to be enforceable. When I say enforceable, I mean you could actually go to court and have the courts enforce the terms of the agreement. But then there are other contracts that might be subject to the statute of frauds we were just talking about, which is the federal or national law. And any type of contract that is subject to the statute of frauds, then those agreements must be in writing if you expect it to be enforceable. Okay? Doesn't mean it has to be in writing necessarily, but if you don't have it in writing, don't try to go into court and have it enforced, because it's not going to be enforceable. So we need to know what types of contracts must be in writing and which types of contracts maybe are not required to be in writing. And we're going to talk about those and make sure we understand it. But I'll give you a heads up right now. If it happens to be a contract or an agreement dealing with a real estate transaction, I can just about guarantee you it better be in writing. It better be in writing if you expect it to be enforceable. We'll talk more about this as we go through, but I'm just telling you, both legally and if you might be in a state where there are certain types of agreements, or real estate type agreements that are not required to be in writing. Just because they're not required to be in writing does not mean it's not a very good business practice to put things in writing. I'm just telling you, it's going to be very difficult to enforce terms that have been agreed upon if it's not in writing. How's the judge supposed to know that you actually agreed upon it? I know you might be saying, because I'm saying we did agree upon it, but the other person saying we didn't agree to that. How do you enforce that? So I'm just telling you, you need to put things in writing. Anything in writing. If you expect it to be enforceable, it better be in writing. Okay, moving on. Then we take a look at bilateral contracts. Bilateral, first of all, how many is bi? Bi means two. So if you have a bilateral contract, that means you have two parties that are bound to do something or have promised to do something. For example, if you have a contract of sale, that means you have one party promising to sell their house, another party promising to buy the house. So you have two parties promising to do something within the contract. That's a bilateral contract. But then you may be dealing with unilateral contracts. Well, what does uni mean? One. So if you have a unilateral contract, that means there's only one party that's going to be bound to the contract. You might have multiple parties involved, but there's only one party that's going to be bound to the terms of the contract. The other parties will not be, at least not initially. Now, the most common type of real estate contract that would be considered unilateral is what we call the option to buy, an option contract. And, if you're not familiar with an option to buy or don't know how that works, no worries. We're going to be talking about it as we go through. But just real quick, with an option, an option to buy is really what it sounds like, where the buyer and seller agree that the buyer will have, just for example, you've got 1 year. I'm going to give you 1 year option to either buy this property or not buy it. So they've just agreed to an option because the buyer's not sure that they actually want it. Pretty sure I want it, but either maybe there's still some doubt, or maybe right now I'm not able to, but I think within the next year I will be able to go ahead and buy the property. So they will agree to an option to buy. And we'll talk about how that works. But the point is this: if it's an option to buy, that means the buyer has an option. They can buy it, but they could decide not to buy it. So the contract is not binding on the buyer, but it is binding on the seller. If that seller agrees to an option with the buyer, then that means if the buyer opts to buy, then seller, you must sell. The seller has no option here. So there's only one party bound to the contract. So that's why we would refer to this as a unilateral contract. Again, we're going to get deeper into these contracts a little bit as we go through. We're just trying to make sure we understand some terminology here. And then we've got executed and also executory contracts. Y'all be careful for test purposes that you don't get these confused. Y'all, there are a few terms that are very similar that we're about to go over. But if you have an executed contract, executed means all parties have fulfilled their obligations. They've done everything they agreed to do. So in other words, at least in relation to real estate, an executed contract means we've closed. We've closed. The buyer bought it. The seller sold it. Everybody did what they agreed to do. Now the contract is considered executed. It's over. It's done. But it could be an executory contract. Now, executory means we have a property under contract, but we have not closed yet because there's still some things that either the buyer or the seller still has to do to fulfill the obligations of the contract. So not everything has been done yet. Primarily, we have not closed yet, right? So there's still some things that have to happen. But during that time, the contract is considered executory because we have not closed. But once we close, it's now executed. Okay, so don't get those two mixed up. And then here's a couple more similar terms: void and voidable. Now, I will tell you, this one causes people problems on the test. I'm just telling you right now. Really not sure why it's such a problem or an issue, but I'm just giving you a heads up right now. This is a very common void. We confuse void with voidable. Well, first of all, what does void means? Y'all, if something is void, y'all, by law, in fact, the way the law defines void is, for all intents and purposes, it never ever existed. You never had an agreement. Well, if there was never an agreement, then obviously there's certainly nothing there to be enforceable, nothing there to have any legal effect at all, because void means it never even existed. That's what void means. So y'all keep that in mind. Void means it never existed. Yeah, I got it right here. Nope. If it's void, it's gone. It's like it never ever even existed. So, well then what is voidable? Well, a voidable contract just means you have an agreement that can be voided by one of the parties. Now, again, notice it says it can be voided. It doesn't say it has been voided. It means we have a contract in a state that, for whatever reason, one party or the other could void the contract. So it's considered voidable during that time. So let me give you an example of when you might have a voidable contract. Say I'm the seller and I receive an offer on my house. Y'all, I want $200,000 for my house, and I get an offer for 175. Y'all, obviously, this is very common example here. Well, so the seller says, I can't go 175. That's just too low. So they decided to make a counter offer. They said, how about 190? So they counter back to the buyer saying, I'll agree to 190,000. Well, when the buyer receives that counter offer, and by the way, this is what anytime you're dealing with a counter offer, that's when voidable comes into play. Because now that buyer's got a decision to make. And basically, he's got he's got to decide on one of three options here. He could just accept the counter and say, all right, I'll agree to pay 190. That's one option. He could counter the counter and say, no, I'm not paying 190. How about they'll counter back and say, I'll do 180. So that's another option, to counter the counter. But the third option, the buyer could just say, you know what, I'm not playing with you no more, seller. You're being ridiculous on what you think the property's worth. I'm not even playing no more. So the buyer could just reject the counter. And obviously if they reject the counter, it's now void. It's if it never even existed. Once either party rejects an offer or a counter offer, it's over. The entire contract becomes void. But wait a minute, what does voidable mean? Well, during the time the buyer is trying to decide what to do. Well, do I want to accept this counter? Do I want to counter the counter? What do I want to do here? Well, during that time, the contract is considered voidable. Because if the buyer, because it's not void yet because the buyer hasn't decided what to do yet. So during that time, it's just considered voidable because one of the options would be to reject the counter. And then that would make it void. So, y'all, the main thing I want you to see, well, one, I want to make sure you know the difference between void and voidable. But, y'all, when buyers and sellers start or decide they want to make a counter offer, either party, it's very important that we make sure they understand what they're doing here. Because, what I have learned, this is what's going through a lot of people's mind. I say people, buyers and sellers, because they don't understand what they're doing. There's a reason they're hiring you to walk them through this process. Because they don't understand a lot of this stuff. That's why you need to understand it. But, a lot of times, the seller might get an offer and they'll say, well, you know what, that's actually an acceptable offer. In fact, let me just give you I have sellers tell me this all the time. Frankie, I would like to get, say, $200,000. I would love to be able to sell my house for that. But a question I have is that your bottom line? Because I need to know what's the lowest you're willing to go. Not that I'm going to try to get it under contract for the lowest price. How do I can't negotiate on your behalf if I don't know what my parameters are, right? Obviously, I want to sell it for as much as we can get it for, because I've typically, not every time, but typically the more the house sells for, the more money I make, right? Especially if you agree to a commission based on a percentage. The higher the sales price, the higher the commission. So the agent has, what's the word I'm looking for? We want to sell it for as much as it can sell for as well. So I'm not trying to find out what's the lowest you'll go so that I can use that against you, seller. But I do have to know, how to negotiate this deal. Because it may be that the only way we're going to sell it is go with the lowest price here. So anyway, but say the seller said, I'd like 200, but Frankie, if it came down to it, I guess I would consider 190. I would sell for 190. Obviously, I want more. Do everything you can to get more, but 190 is going to be my bottom dollar. But then we get an offer, and it's for 195. Well, that's not a full price offer, but seller, that's in the window of acceptability. You said you'd be willing to sell it for 190. You got an offer for 195. What do you think the sellers want or thinking about doing here? Well, let's counter back. Let's see if they'll pay more. Let's just counter back at the full price, 200, and see what happens. Now, look, whatever your client says they want to do, then that's what you're going to have to do. Y'all, they're the boss, right? But at the same time, I think we have an obligation to make sure they're making an informed and educated decision here. Because what I've learned, for example, in this case, the seller, what they're actually and probably thinking is this. Let's just counter back at 200 and see if they would be willing to, we're trying to bluff them. That's what we're trying to do. Let's just see if they'd be willing to pay the full price. But if they say no, then we'll come and say, oh, okay, well, we're just kidding. We'll take the 195. You can't do that. You cannot do that. But yet a lot of people think they can. And they want to play this game. Well, wait a minute. Well, why can't you do that? Well, because if you counter back at 200, what's the status of this offer now, or this contract? It's now voidable. It's voidable now by the buyer. Because seller, you made a counter offer. Because the buyer could reject your counter and say, no, forget it. I wasn't all that crazy about the house anyway, and you just convinced me I don't want it now. So they decided to just reject the counter. Well, y'all, once that buyer rejects the counter, it's over. There is no more contract. You can't come back later and say, oh, but I was just kidding. We'll take the 195. You can't do it because there's no longer an offer. There's no longer a contract. So, y'all, just make sure they understand the risk they're taking on, which I don't think is a very good idea when you have what you wanted in your hands. You had it in your hands and you decided to be greedy, trying to get a little bit more. I'm telling you, I see it time and time and time again where they wish they had never made that counter. You know, especially, now look, if the offer is not acceptable, then, make the counter. You have nothing to lose. I'm not selling it for this, no way. So if they want to walk away, that's up to them. But then go ahead and make the counter. But once you have an offer in your hand that meets what you decided or what we decided would be acceptable, and you still try to play these games, I'm telling you, you're risking a lot here. You're risking a lot. So I don't think it's a good idea. And I would say the same would apply to buyers. Buyers try to play that same game where they're willing to play, and maybe the seller counter back at a price that they were willing to pay, but they want to try to push it a little bit more. Let's see if we can get them to come down some more. Eventually somebody's going to say, no, we're done. And then guess what? It's over. It's over at that point. So I'd be careful with these counter offers, because what does the counter offer do, or what does the counter offer render the contract as? Voidable. And at the moment either side just says, no, I reject it, then it's void. It never even existed at that point. So you can't come back and say, oh, I just kidding, we'll take your other price. Nope. Not legally, you have no contract to even come back with now. Okay. All right, I kind of beat that up a little bit. Now we look at the terms enforceable and unenforceable. I think we've kind of already talked a little bit about this already. But for for a contract to be enforceable, we're talking about like if you have to go to court, can the courts enforce the terms of the contract or of the agreement? Well, if it's an enforceable contract, then obviously the courts can enforce the terms. Well, what makes one contract enforceable and another one unenforceable? Well, again, y'all, typically, and certainly in real estate, is it in writing or not? Now, again, not every implied or oral contract is unenforceable. Y'all, some of them are enforceable depending on what type of agreement it is. But if you have an agreement that is subject to the statute of frauds, I know we haven't talked about it yet in detail, but y'all, the statute of frauds just says any contract that is subject to this act, it must be in writing if it's going to be enforceable in court. So enforceable contracts means it's in writing, assuming it is subject to the statute of frauds. But if it's not in writing, y'all, if it is subject to the statute of frauds and you do not have it in writing, then the contract is just unenforceable. You still have a contract, it's just not enforceable because it's not in writing, okay? Okay, moving on. Here's a couple more terms, valid and invalid. Well, honestly, valid and invalid kind of goes right along with enforceable and unenforceable. Y'all, in fact, you can't really separate the two. And here's what this is saying here. In order, another requirement to have an enforceable contract, the contract must be valid. If the contract is valid, then it is likely going to be also enforceable. But if the contract is invalid, then obviously that's not going to be enforceable. So that would fall under the unenforceable. Well, what would make a contract valid or not? Well, the law has identified some critical, or what we call essential elements that must be included in a contract. Both parties must agree to certain things. Now, typically there's a lot more than what we consider essential elements. There's a lot of stuff within the contract we're agreeing to. But y'all, in fact, I'll just tell you, y'all, there are 4 essential elements. And all 4 of these elements must be in the contract and agreed upon. And assuming they're there and agreed upon, then you have a valid contract, which means you could also expect it to be enforceable. But if any of those 4 elements are missing or lacking, not clear, then the contract is considered invalid, and therefore it would not be enforceable. Okay? So now we're thinking, well, so what are these essential elements? Well, funny you should ask, because we're going to talk about those here in just a few minutes. Then you see a term called reformation or contract reformation. A lot of time people, I don't think, maybe really know the term or the terminology here, even though we're dealing with this all the time in real estate. Y'all, this is a very common situation we have to deal with. And here's what we're really referring to here. If you have a contract of sale, and I'll just say, in our market, the contract of sale that we tend to use here is 8 pages long. The contract of sale is 8 pages. I'm sure some states may have contracts that have fewer pages. Some of them will have more. It will vary, and none of that matters for what we're dealing with here. But the point I'm trying to make is this. These contracts are already pre-printed. So basically it's just fill in the blank. So it's not like when you go to make an offer or write up a contract sale, you're actually or physically writing up a contract from scratch every time. We have pre-printed contracts. They're already done. All you got to do is fill in the blanks. So when we say you're going to write a contract, You're not really writing the contract. Again, you're just filling in blanks within the contract. It's already written. It's already pre-printed. Well, here's where some issues might come in. Say one of the agents involved, either listing agent or buyer's agent, decides, they write something into the contract that they want the other party to agree to. So they just handwrite it. It's common. Agents do it all the time. Not trying to suggest that's a good idea, by the way. In fact, I would just tell you, when you start adding stuff to the contract and you start doing more than filling in the blanks, you might want to get some legal help here, because that could be considered practicing law. When you start adding to contracts, you're writing in additional agreements or provisions to the contract. I know agents do it, but I'm just telling you, you better be careful with it. Now, in some states, the agent's not even allowed to fill in the blank. But I think most states are okay with allowing agents just to fill in blanks. That's not considered practicing law in most states. But when you start handwriting a full, several sentences or whatever, you're now changing the contract. And that potentially could be considered practicing law. So you want to be careful about that. But the point is, agents do it. They'll write stuff in the contract, and oftentimes things that they put right into the contract may completely contradict something that's already pre-printed somewhere else in the contract. Part of the pre-printed contract, it may state whatever, and then the agent goes and writes something in there that completely contradicts what it says somewhere else. So, we got an issue here, right? We got conflicting statements. In one area, it says one thing, and in another area of the same contract, it says something completely different, from where the agent wrote it in. Well, when you have a situation like that, then which provision are we agreeing to here? Do we go with what was pre-printed, or what was handwritten by one of the agents, or maybe either the buyer or the seller? Which one are we going with? When you have a contradiction like that, that's when reformation comes into play. And contract reformation states anything handwritten carries more weight than anything pre-printed. So in this scenario, if you handwrite something into the contract and it contradicts something that was pre-printed somewhere else, and assuming everybody agrees to the terms and what was put there, then you are agreeing to what was handwritten. That handwritten is going to carry more weight than what was pre-printed. And you need to remember that. But I'll also tell you, reformation, again, also says not only does handwritten carry more weight than pre-printed, letters carry more weight than numbers. Well, what does that mean? Well, that may not really apply a lot, or if at all, when we're practicing real estate, quite frankly, but just to make sure you understand it. Let's say I go to the store, I'm shopping at whatever store, and I got to pay for whatever. I know this is unheard of today, but let's say I'm going to write a check for payment. Believe it or not, especially you younger people, that's how we used to pay for things. We would write a check, either give them cash, or we'd write a check for it. But let's say I write a check. Well, if you've ever written a check, which maybe some people haven't anymore, I know we don't do that much anymore. But anyway, if you write a check, you got to put, say for example, you're writing a check for $100. Well, you got to write the numbers, $100, and then on the line below it, then you got to spell out the amount of money. So you're putting both the letters and the numbers on the check. But let's say I put I wrote $100, y'all, the numbers, but for some reason, when I was writing it out, I wrote out $10 on the line below it. So, y'all, again, I've got a contradiction here. Y'all, one place on the check says it's $100, and then right below it, when I was writing it out, I put $10. Well, how much is the check good for? $10. Again, because you have a contradiction. It says one thing here and has says something else in another place. And again, contract reformation says letters carry more weight than numbers. So whatever dollar amount you spelled out, y'all, that's what we're going to have to go with, not the numbers. Okay? So anyway, so what does reformation mean? Handwritten carries more weight than something pre-printed, and letters carry more weight than numbers. Be good to know. All right. So now we get into what these essential elements are for a valid contract. Remember we said there were 4 essential elements. And I highly recommend you memorize these elements. You got to know what the essential elements are in order to have a valid contract. Y'all, just 4 of them. And quite frankly, I think they're all common sense. But all 4 of these must be agreed upon or exist for the contract to be valid. Well, number 1, there has to be an offer and an acceptance. Y'all, that kind of makes sense. Y'all, how are you going to say you've got a contract that you've agreed upon if there was never an offer made, or even if there was an offer made, it hadn't been accepted yet? So that makes sense. There's got to be an offer and acceptance. Y'all, once the offer is accepted, y'all, that's the first element. Then it says there must be legal consideration. Now pay attention to this one. When we talk about consideration, consideration can be considered valuable, or in some cases it could be considered invaluable. But one or the other must be present and agreed upon in the contract. Now, typically, and especially in real estate, we're going to be dealing with valuable consideration. Well, what is valuable consideration? Well, it would be the price paid. So if I make an offer to the seller and say, I offer you $200,000 for your house, then my consideration is $200,000. Y'all, that's valuable consideration. Y'all, there has to be some amount of consideration. Got to be there. Now, the law does not say how much or how little it has to be, but there has to be some amount of consideration. Valuable consideration. Again, valuable being the price paid. Well, wait a minute. So are you saying, I can't just give my house to somebody if I want to? You mean they have to give me at least some amount of money in order to convey the property? No. But if there is no valuable consideration, in other words, there's no money put up or being purchased, if it's not valuable, then there must be invaluable consideration. And the law says there's only one type of legal invaluable consideration, and that is for love and affection. So in essence, you would have to write that into the contract. Instead of putting a dollar amount that would indicate the valuable consideration, you would just write in for love and affection. That would represent invaluable consideration. But one of the two has to be agreed upon. Either love and affection or some dollar amount. Some valuable consideration here. One of the two must be there. Okie dokie. Then it says we have to have competent parties. Again, that seems like a no-brainer, doesn't it? How in the world can you consider a contract to be valid or enforceable if one or both of the parties are incompetent? Well, what would render someone incompetent? Well, one is you have to be of legal age. And I think in most states, if not all, that legal age is 18 years of age. So legally speaking, if you're anyone that is not 18 is legally incompetent, right? So you got to have competent parties 18, it must be at least 18 years of age or older to be considered competent. It says an insane person, someone that has been medically evaluated and deemed to be insane, they're incompetent. So to have competent party, we have to have sane people. And sometimes I will tell you in real estate, I question how sane some of my clients have been. But I don't think they've been medically determined to be insane, so we were able to make it work. Anyway, you got to be sane, and then you also have to have competent. You got to be competent. Now, what are we talking about there? If you're drunk, if you're inebriated, you're high on drugs, whatever the case, you're not in your right mind because you're toasted, whatever, then you are considered to be incompetent at the time of the agreement. Therefore, because that means we don't have competent parties. So you're lacking at least one of the four essential elements. That would render the entire contract unenforceable, right? Because you don't have competent parties, or at least they weren't competent at the time they signed or agreed to the contract. We're going to talk some more about that here probably in the next hour. But then the fourth and last essential element, that whatever you're agreeing to has to be for legal purpose. Got to be legal. That again, common sense. If you agree to do something that's illegal, do you think it's a good idea to try to take it to court and ask the judge if he'll enforce it? Probably not going to be a good idea. If you go to court and say, Judge, I gave this man $100 and I'm supposed to get back a big old bag of marijuana in return. I gave him the $100 and he never gave me my marijuana. Probably not going to be a good idea, right? At least not in most states, not in the state I live in anyway. It's illegal, and marijuana is illegal in my state. I know there are some states that have made it legal, and so that might be something you could go to court over, but not here. Probably don't want to go to court trying to enforce that. Look, whatever we agree to, we must have competent parties. So, let me just say this try to cover this real quick to close out what we want to do in this hour. But let's say you got two parties, somebody wanting to sell a piece of property, another person wanting to buy the property, and they decide to get together. You know what? Let's go have a beer. Let's go get a beer. Let's go to the bar and sit down and talk about it. See if we can't negotiate the actual conveyance of this property. And they do. They actually work it out, and both of them sign a contract to sell. But while they were doing this, they both they were drinking beer or liquor, whatever. And I know some people say, but you can drink some and not be drunk and not be considered incompetent. Well, let's just say in this case, they were totally wasted. They were wasted, had to get Uber to take them home. But they still signed the contract. In that scenario, can we go to closing and close, given that situation? And I will tell you, most people will say, no, you can't do that. And I ask, why not? Well, because one or both were incompetent at the time they signed the contract, because they'd been drinking so much. They were wasted. Here's what you got to be careful of, and for test purposes. First of all, yes, they can close if they choose to. What you got to understand is just because the contract may not have been valid, it doesn't mean, it just means the contract is not enforceable. It's unenforceable. It doesn't mean the contract is illegal. Don't confuse that for test purposes. Just because a contract is considered invalid and or unenforceable does not mean it's illegal. It's not illegal to drink beer and sign a contract. If it was, a lot more people would be in jail. So it's not illegal, it's just unenforceable. So when would this matter? If one of the parties woke up the next day and realized, oh, I can't believe I agreed to do that. The only reason I did that is because I was drunk. So you know what? I'm not buying this property. I agreed to it in a state of mind that was, I should have never agreed to that. So I'm not agreeing to it. So if one party decides to back out, then there's nothing the other party can do about it because it's not enforceable. But as long as everybody still gets up the next day and still likes what they've agreed to, and they both show up to the attorney's office or the title company and close the deal, then it's all fine. It's fine. So again, just don't confuse enforceable or unenforceable with legal or illegal. Not the same thing. Okie doke.